Further to this video. Watchtower, Jehovah's Witnesses, Letter of Appeal to the Government of Norway. The department responsible for religion have responded to the infamous letter from Watchtower, asking for their money back because of the shunning update. Telling Watchtower to shove it up a place the shun don't shine. Norwegian original here. Be aware that this does not affect the upcoming court case in February. This was Watchtower trying their own stunt to avoid the trial through the bureaucracy instead. Failed. Ministry of Children and Families. The Royal Department for Children and Families. Jehovah's Witnesses. November 11, 2024. Decision, conversion request not accepted. Jehovah's Witnesses. We refer to the letter of October 24, 2024 with a request to reverse the following 6 decisions. 1. The State Administrator's decision on January 27, 2022 on the rejection of claims for state subsidies for 2021. 2. The decision of the Ministry of Children and Families on September 30, 2022, which upheld the decision of January 27, 2022. 3. The State Administrator's decision on December 22, 2022 on refusal of an application for registration under the Religious Communities Act. 4. The State Administrator's decision on November 7, 2023 on rejection of claims for state subsidies for 2022. 5. The State Administrator's decision on November 7, 2023 on the rejection of claims for state subsidies for 2023. 6. The State Administrator's decision on June 18, 2024 on rejection of claims for state subsidies for 2024. The Ministry's conclusion. The conversion request will not be accepted. The decision not to reverse the above-mentioned decision is not a single decision in the sense of the Public Administration Act, and therefore cannot be appealed. Content of the conversion request. The Jehovah's Witnesses point out that the above-mentioned decision
has its background in the Jehovah's Witnesses' religious teachings about limiting contact with a person who has been removed from the congregation or who has himself withdrawn.
Jehovah's Witnesses will inform about
a recent adjustment, which has been made on a worldwide basis, in our religious practice in this area.
The most important adjustments are then summarized in 4 bullet points. Among other things, it is stated:
if a baptized minor commits a serious sin, the elders will have a conversation with the minor and his Christian parents or guardians to find out what the parents have already done to help their child make the necessary changes and regret. If the minor has a good attitude and the parents manage to reach out to him, it may be that the eldest will come to the conclusion that it is not necessary to do anything more about the matter. It is the parents who have a biblical responsibility to correct the children in a loving way. For that reason, it will be even rarer that a baptized minor who has committed a serious sin will be able to be removed from the congregation. Persons who belong to the congregation choose whether they want to invite a person who has been removed from the congregation or has resigned to a congregation meeting. They can also choose to greet the person and welcome him or her to the meeting. If the person expresses that he wants to return to the congregation, the elders can also arrange for someone in the congregation to study the Bible with him, even if he has not yet been readmitted. A person who has been removed from the congregation or has chosen to withdraw may be reinstated within a few months if he shows genuine repentance.
In the letter of October 31, 2024, additional comments are given to the above-mentioned letter. JW refers to the attached expert opinion from Jean Zeugen, former head of the UN Children's Committee, and states that it concludes that
the relevant religious practices of Jehovah's Witnesses are in accordance with, and protected by, the UN Convention on the Rights of the Child.
Administration Act Section 35 first and second paragraph. According to Section 35 first paragraph of the Public Administration Act, an administrative body can reverse its own decision without it being appealed if a. the change is not detrimental to anyone whom the decision is aimed at or directly benefits, or b. notification that the decision has not reached the person concerned and the decision has not been publicly announced either, or c. the decision must be considered invalid. Section 35, second paragraph, states, if the conditions according to the first paragraph exist, the decision can also be overturned by the appeal body or by another superior body. The Ministry's assessment. The Ministry cannot see that the request for reversal contains information which indicates that the decisions must be considered invalid or that they should be reversed on another basis. Cf. Administration Act, Section 35 first and second paragraph. In our view, the contents of the two quotations above are suitable to confirm that the state administrator and the ministry has based its decisions on a correct understanding of Jehovah's Witnesses' practice relating to contact with people who are excluded or have opted out. The main features of the practice remain. Reference is made to the Watchtower Study Article 35 from August 2024, Help for those who are removed from the congregation, where the following is stated in Section 14, the Watchtower's emphasis.
Does what we have seen now mean that we absolutely should not contact someone who has been removed from the congregation? No, not necessarily. Of course we don't want to be with him socially, but we can use our Christian conscience to decide whether we want to invite him to a meeting. For example, we may want to do so if he is a relative of ours or we were close friends with him before he was removed from the congregation. How should we treat him if he comes to a meeting? Previously, we would not greet such a person. Hitherto, each individual must use his or her Christian conscience to choose what he or she wants to do. Some feel that they can greet him or welcome him to the meeting, but we don't want to have a longer conversation or do other things with him.
We assume that it is still the case that any baptized person can be excluded from Jehovah's Witnesses, including children. Exclusion entails a strict, systematic, and targeted social ostracism of the excluded person, also from family and relatives who do not live in the same household as the excluded person. Baptized persons who withdraw from Jehovah's Witnesses, including children, shall be subjected to the same social exclusion as excluded persons. The practice of exclusion violates children's rights. Cf. the assessments in the state administrators and the ministry's decisions. With regard to the statement from Jean Zeugen, which is attached to the letter of October 31, 2024, we would firstly note that this seems to be based on a different understanding of the practice of Jehovah's Witnesses than the one the ministry puts as a basis. Cf. the points above. On page 13 and 14, he writes with reference to a judgment from the Court of Appeal in Ghent, to which Jehovah's Witnesses have previously referred.
In the present case, being excluded from the religious community does not necessarily mean rejection or isolation, even if the adolescent is, in fact, distanced from the other members, but not necessarily from everyone and not from his or her family. It would appear that the children's relationship with their parents is not affected and that any social isolation would only concern other community members.
The decisions in the case are based on evidence, mainly the Jehovah's Witnesses' own texts, which support the following understanding of the practice. The members should not normally have general social contact with excluded and deregistered family members who do not live in the same household, including children and siblings. As soon as a child who has either been excluded or has withdrawn from Jehovah's Witnesses, becomes of age and moves on his own, it is expected that the parents and any siblings who are members of Jehovah's Witnesses will no longer have regular social contact with him. The scholar of religion George Coercive, who has written several books about Jehovah's Witnesses, states the following about this in the article. Jehovah's Witnesses, Disfellowshipping, Shunning, and the Ghent Ruling, published in Bitter Winter April 20, 2021, are emphasis.
The Society's sanction of shunning applies to baptized members, adults and minors, and those who have dissociated themselves, that is to say, those who have formally expressed in writing a desire to be no longer part of the Watchtower organization, or whose actions plainly demonstrate a desire to leave, such as regularly attending a mainstream church, joining the army, or voluntarily accepting a blood transfusion. Members may not associate with a disfellowshipped or disassociated individual. It is also worth noting that reinstatement is possible, and indeed encouraged. The elders will attempt to visit the disfellowshipped member at least once a year to offer counsel and to determine whether the ex-member might be persuaded to return. However, it is disingenuous to believe that family ties remain intact, and that only spiritual fellowship is withdrawn. Bitter Winter quoted the statement, "Since being disfellowshipped does not sever the family ties, normal day-to-day family activities and dealings may continue." Yet, by his course, the individual has chosen to break the spiritual bond between him and his believing family. Keep yourselves in God's love, 2008, 2014. This might seem to suggest that family relationships remain the same, but that the disfellowshipped member may not participate in the weekly family worship evening. The situation is not quite so simple. So long as the household remains together, normal family activities take place. If the father of the household has been disfellowshipped, he will still be permitted to eat with the others, watch television, go on family outings, and have normal relationships with his wife, including sexual relations. He is still the head of the household, to whom his wife should be subject, unless his demands are contrary to Jehovah's law. If some other member of the family is disfellowshipped, normal familial relationships are intact, but they will be excluded from the family worship evening. Instead, the father is encouraged to give them one-to-one spiritual counseling. What the offender may not to do, however, is to speak to non-family witnesses who call. The offender is not normally required to leave home, certainly not if he or she is a minor. However, one Watchtower publication states that it may be necessary for a householder to ask a disfellowshipped member to leave. This would be considered appropriate if they continue to engage in unacceptable practices, for instance if they repeatedly came home drunk or persistently stayed out late with a non-believing partner. Once the offender leaves the home, then social interaction discontinues. Two Watchtower videos depict parents refusing to open a text message from disfellowshipped children since they are no longer allowed to have social contact.
Zermatten's statement is characterized by the fact that he emphasizes to a small extent the importance of the psychological strain associated with the practice described above. In our opinion, it is not appropriate to describe the consequences for a child of being excluded from Jehovah's Witnesses as
less pleasant,
as Zermatten seems to do on page 13 in the statement. Depriving a teenager under the age of 18 of general social contact with friends and family/relatives outside the household, and in addition predicting to him that almost all contact with the family in the household will cease when he becomes of age and moves away from home, is in the ministry's view compatible with descriptions of negative social control and psychological violence. Cf. the assessments in the state administrators and the ministry's decisions. The ministry then sees to it that this could be the consequence for minors if, for example, they have caressed their lover without regretting it afterwards or have made use of their right to withdraw from the religious community. Zermatten also reviews sanctions within other religions. To this, the ministry would like to note that it is not unusual for religious communities and other member organizations to have rules on exclusion, and that these are occasionally used to take away membership from people who act contrary to the organization's purpose and interests. However, it is very unusual for such exclusion rules to mean that the remaining members are asked to break off almost all contact with close family members and others who have either been excluded or have themselves resigned from the organization. This is not commented on by Zeugen. The ministry cannot see that the review is of significant importance either for the assessment of children's rights or for the issue of discrimination. Sincerely, Eric Saglai. Dispatch Manager. Geir Telsto. Head of Investigation.